Welcome to the Thursday edition of Anglican Unscripted. This is Legal Victory Week for Anglicans. Maybe, we'll see. I'm Kevin Carlson.
And I'm Alan Haley, and today is Thursday, February 5th, 2015.
All right, as we alluded to in the intro, there's a victory. And Alan and I kind of want to go through this one step at a time, explaining that it's not the ultimate victory. That was actually won by Christ many eons ago. This is the legal victory, kind of fighting the evil that's creeping in the church. And I think it'd be a good chance to step back here because there's not been a lot of legal victories for the Orthodox in the church. Is this the biggest one to date?
Well, it's another one in the string of diocese cases.
Mm-hmm.
And that's what started the turnaround in this parade of court decisions. The ones where the parishes tried to strike out on their own, apart from the dioceses they used to belong to. They had a smaller success rate there because the Dennis Canon would frequently be enforced against them. But the Dennis Canon doesn't apply to dioceses. And so in there, the Episcopal churches had to, in those cases, with San Joaquin, with not Pittsburgh, because there was a stipulation that covered that, but Quincy and Fort Worth, the tech had to pretty much improvise an argument based on historical association. And of course, what counted against the argument was that during the Civil War, dioceses pulled out. And since then, the law has changed. We now have, in the 21st century, and since the 1930s, the First Amendment has been applied to the states through the 14th Amendment, and that contains, the First Amendment contains the freedom of association, which means that groups are free to have members join them, and the members can then leave them whenever they like. There's no restriction you can place on them. You have a freedom to associate, and as Judge Goodstein pointed out in their decision, the freedom to associate includes the freedom to disassociate. So that's what happened here, and that's what these dioceses, and it's a different story, of course, again in South Carolina, because there was the precedent there of the All Saints Waccamaw decision.
They had the precedent, but they also had Diane Goldstein, Judge Goldstein here. And let's talk a little bit about how she took on this case. She may as well have put in the title, "We don't want carpetbaggers or scallywags coming down here to South Carolina." It was quite the, I read through the decision, it's at no point did she give Tech any leeway in her decision.
No, that's true. She didn't give their arguments much more. And, but if you look at the transcript and the kind of things they put on for her, it was kind of ludicrous in many cases. The expert witness, McWilliams, for example, she did deal with him, but he himself shot himself in the foot because he admitted on cross-examination a key part of his testimony had been not accurate. And so that was the problem with Tech's case in here. As I followed the transcripts, they did not put on that strong a case. They were going through the motions. It's as though they were expecting to win their cases at the higher level of courts on appeal. But that strategy, again, is a very remote chance of winning because you have to build your foundation at the trial court. That's where all the facts come in and where the ruling is based on the evidence. The appellate courts don't rule on evidence. They don't weigh evidence and make their decisions. They look at the law as it's been applied to those facts that came in. And here, as I say, we've got binding precedent on all the trial courts in South Carolina from the All Saints Waccamaw decision. And that case had two very good points to it. One was that the Dennis Canon itself, of course, has no effect in South Carolina. Can't create a valid trust because it doesn't require the consent of the person actually owning the property to put it in trust. And the second point the Waccamaw decision made was that the churches, parishes even, can change their governing documents in accordance with South Carolina law for nonprofits. And if they follow all that procedure, they can change their documents so as to move themselves right out of a diocese, just the way a diocese can move itself right out of a church. So with those points as precedent, I think the outcome was pretty much foreordained. It's just that Judge Goodstein had such a panache and style that this is really a decision with a lot of flair. And I think it's going to stand up well on appeal because she's spent a lot of time crafting it carefully, building her points, and showing how each one rests on the one before it. And she's addressed the whole case thoroughly. So I think this one is going to be not a problem to on appeal for Bishop Lawrence and his diocese.
Well,
but we'll see.
Let's talk about some of the strategies TEC has used in the past. One is to wait out by spending to death the opposition. And you've been part of those cases. You've been part of the San Joaquin case where they never want to go to trial. It's delay here, delay here, delay here, and then go for a quick decision with a judge hasn't been paying attention, and they win. And we call that the Hail Mary. And they've won several times in the past 4 or 5 years on Hail Mary passes.
Right. Well, even in San Joaquin, my own case, the trial court judge there is a total complete study in contrast with Judge Goodstein. He was not as interested in the case. He asked the parties to submit written decisions at the end of the case for him to adopt, and he simply adopted TEC's written decision without much thought or consideration. So we now have to take that up on appeal again, and I'm hopeful that we will be able to reverse it on appeal, but my goodness, that's been 2 times now. We will have to go up on appeal and each time get the trial court turned around and reversed. And then that, of course, would lead to a 3rd trial. So, I mean, that case is going to be never-ending. But at least in South Carolina, the appeal, it could be expedited in this way. The appeal is normally first there'll be a whole lot of post-trial motions. Watch for TEC to move for reconsideration, move to a new trial, move for vacate the judgment, and all the things they could do.
They should move for a new venue.
Well, they won't be able to do that. But we'll try to drag it out because they don't want things to get up to the Supreme Court with the current membership of the Supreme Court in South Carolina. That's the same membership that decided the All Saints Waccamaw decision. And so they would just as soon hope that there might be some different thinking on the court by the time it gets up there. But once the appeal is taken to the South Carolina Court of Appeals, then Bishop Lawrence's attorneys can do what they did earlier in this case. They can ask the Supreme Court to intervene directly and take the appeal from the Court of Appeal and handle it and decide it right then and there. And that's probably what will happen in this case.
Well, let's talk about how this case now reflects on what we call precedents. This is a well-written, it would probably stand up against appeal. Can this case be used as evidence or example in other trials now?
Well, it has persuasive force only because it's a trial court decision. And a court of appeal is not going to accept it as the final statement of the law. It, however, can be cited along with a couple of other cases, and particularly now the Illinois decision, which is by an appellate court, and which Judge Goodstein referred to and cited in her own opinion. That is precedent, and that's something that another court of appeal, particularly the one in California, I think is going to take a good look at. The one in Texas also, Fort Worth. Right now that's back down at the trial court level too, but he's going to take a look at the Illinois decision because, again, that's a decision by the state's highest court, the Illinois Supreme Court having refused to take the case further. And that becomes then what we call a precedent because it is at the appellate court level and there's been no further appeal and the decision's become final. I suppose it's theoretically, I don't think the 90 days has run out yet for them to take a petition up to the U.S. Supreme Court from that case, but any petition like that would have practically zero chance of success, in my view.
Right.
So for all purposes, that's final.
But if Judge Bruno really got mad and wanted to leave the Episcopal Church, he could use Illinois and South Carolina as examples of where a diocese can leave.
Exactly.
That's good. Let's talk now about what this means in the bigger picture, in the spiritual picture. This is a court victory. It is not the end-all victory of victories. And TEC did not destroy itself in court. This is something that's happened slowly over the last 60, 70 years by the liberalism of the seminaries and slowly the takeover of the churches and the deaneries and the dioceses. they did not get where they were by court victories.
No, they didn't. They did it by working their way through the mechanisms of the Episcopal Church and getting the reins to the power, so to speak, and getting the ability to take over the higher offices and echelons, particularly the bishops who graduated from the seminaries and got elected or appointed to be bishops. And then they control, of course, which clergy get elevated in their own diocese and which ones go to seminary and so on. So it becomes a process over time that as the composition of the House of Bishops changed, Bishop, it's hard to think now, but Bishop Pike used to be in a minority.
That's right. He was an outlier by far.
But they couldn't even bring themselves to discipline him. And so the seeds of decay were already set in at that point, and they just grew further and further as the years went by with Bishop Spong and his outrages. Again, not checked, not controlled in any way. And so the House of Bishops has kind of fallen apart from within, and has now lost the ability to rein anybody in, particularly the presiding bishop, who's now going to have to account. For example, she's going to have to go to her treasurer and say, you're going to have to come up with another $1 million or $2 million for this South Carolina case, because the judge is going to order, as part of the post-trial action, Judge Goodstein is going to make an order finding Episcopal Church liable for Bishop Lawrence's attorney's fees. And those could be sizable given all the wrangling that the Episcopal Church dragged him through, taking him up to federal court twice and so on. And that federal case, by the way, still isn't quite dead. It was argued also last week, and based on what I heard at the arguments, I should say, the federal appeals court in Virginia is going to send the case back to the federal judge in South Carolina saying, we don't think you applied the right standard in deciding to abstain from deciding this case. So take the right standard, which we think is this case, apply it, and then if you want to abstain again, that's fine with you, fine with us, and make a discretion. Well, so it will have a little footnote, but I don't think it's going to go anywhere ultimately.
I need some legal advice, and I'm hoping you can help me out here. I have a friend who kind of let somebody get hired who should not have been hired, who had a drinking problem that she knew about, and is this person in authority going to be in trouble for letting this person get hired? I'm just kind of wondering, off the record, if such things happen.
Yeah, there are certain things that can make liability in that case. For example, I don't believe the car that your friend was driving, or your friend's friend was driving, belonged to the Episcopal Church, but provided by the diocese. Right. That would be one test. And the next thing would be if she was on duty at the time, was going from one church function to the other. I gather they said she was headed out to she had a home on the eastern shore of Maryland, so maybe she was heading for some time off. But the problem with that, too, I don't understand, is then she drove back to her apartment after the accident, and her boyfriend urged her to go back and turn herself in. So he wasn't in the eastern shore of Maryland, so I don't know exactly where the facts were. But if she was on, for example, going to a parish visit, anything like that, was on diocesan business at the time, then there's a much stronger chance of being held liable. It's going to be thoroughly examined. You can count on that. The attorneys for the family of the deceased biker are going to look into every possible avenue there.
Yeah, it's interesting because we kind of want to know who knew what. And more is coming out as the current Bishop of Maryland is trying to protect himself. And says he warned certain people that she seemed intoxicated at the pre-concentration dinner. And, all that Al and I are talking about here now is allegations. We're not talking about anything that's going to get us in trouble. But if Catherine Jefferts Schori knew of this issue and said, ignore it, does this hold the Episcopal Church itself, 815, liable?
Yeah, as I said, that's the thread that has to be connected is to show that there was some church business there. Just simply making her a bishop and putting her in her position doesn't create liability unless she's carrying out her functions at the time of the accident. And that's the case here. I mean, that's the question here. So the other thing is, apparently Catherine Jefferts Schori was with her at the pre-consecration dinner. Bishop Sutton claims he said something to Bishop Schori about the amount of alcohol that the candidate was consuming. And then we know that Bishop Schori apparently had a talk with her. And so there's something there that indicates, as I say, that the Episcopal Church at the highest level was aware of the problem just before the woman was made bishop. And that's going to be a significant factor if, as I say, they can connect the other part of the dots and put her doing some sort of church task or mission. She could have been texting on the phone, for example, on a church call or something like that. Anything like that would say that if she's in the course and scope of her employment when she's has this accident, that's the connection that needs to be established to prove liability for the church.
Well, we've done Inside Baseball for 15 minutes. We've told everybody anything they could possibly want to know about the legalese of South Carolina and the possible connections with Tech and Bishop Cook. I want to thank you for your time, Alan, and we'll catch you very soon.
Very good.